There is a judgment sitting on the judiciary's own public website right now. Anyone can open it. It is signed by a High Court judge, and it says, in plain terms, that a British newspaper group broke the law, not according to a tabloid, not according to a grudge, according to the court. And this week, a second judge handed down a ruling in a third case, while the man at the centre of all three was standing on British soil. Tonight, we are not reading a rumour, we are reading the paper. And the paper does not forget. Let me tell you why this matters more than the usual royal noise. For years, the story you were sold about Prince Harry and the newspapers was simple. He was bitter. He was chasing a vendetta. He was, the line went, making it up as he went along. That was the marketing. Tonight, we set the marketing beside the court record. Line by line, date by date, because there is a difference between what a publisher tells the public and what that same publisher is willing to sign in front of a judge. And that gap is the whole story. Tonight we are going through the full picture, the first judgment, the one a judge actually wrote, the second case, the one that ended not in a courtroom but in an apology. The third, the one that reached its ruling this very week. And underneath all of it, the one question nobody who ran those headlines wants to answer out loud. Let's start with who this man is, because it matters to how you read the paper. If you watched that funeral in 1997, you remember the boy walking behind the coffin, 12 years old, in a dark suit, eyes down, a small white card on the flowers that said one word, Mummy. That boy grew up believing the press helped hunt his mother. Whether you agree with him or not, that belief is the engine of everything he has done in these courtrooms. He is not a man who wandered into litigation. He is a man who spent years and a great deal of his own money to put one question in front of a judge. Did they break the law or did they not? And here is the part that makes this land with real weight. In 2 of the 3 cases, he now has that answer in writing. And you have to understand what it took to get there, because that is the part the word bitter was designed to erase. Most people who believe the press wronged them do nothing. They cannot afford to do anything. Litigation against a national newspaper is slow, brutal, and ruinously expensive. And the whole system is built so that the ordinary person gives up long before a judge ever rules. That is not a conspiracy theory. That is how the phone hacking scandal was mostly handled. For years, claim after claim was settled in the quiet, with money and a confidentiality clause attached, so that the public finding never came. The methods were paid for, not proven. The papers kept the story of themselves. What Harry did was refuse that arrangement. He had the one thing almost no other claimant has. He could fund a fight to the end, and he was willing to sit in a witness box himself, under oath, and be cross-examined about the most private parts of his life to get a public ruling. Whatever you make of him, that is not the behaviour of a man chasing a cheque. A man chasing a cheque settles early and stays quiet. He did the opposite. He kept walking toward the one thing the boy behind the coffin never had. A judgment, in writing, on the record. Now, let's talk about the first document, because it is the anchor of the whole thing. In December of 2023, A judge named Mr. Justice Fancourt handed down his ruling in Harry's case against Mirror Group newspapers. This is not a leak. It is a public judgment, summarised on the judiciary's own site. And what it says is remarkable. The judge found there had been extensive unlawful information gathering at the Mirror titles. He looked at a sample of 33 articles. He found phone hacking or other unlawful activity proved in 15 of them. He awarded Harry £140,600, and he made one finding that the coverage often skips. He said the then editor of the Mirror, Piers Morgan, very likely knew of at least one instance of that unlawful activity. Read that again slowly. A High Court judge, not a Sussex spokesman, found unlawful activity, proved in writing, and pointed at the man in the editor's chair. To be fair, and we always do the fair part on this channel, Harry did not win everything. He proved 15 of 33, not all 33. The damages were, by the standards of these things, modest. The publisher had defences, and some of them held. That is real, and I am not going to pretend otherwise. But here is what does not wobble. The core question, did they do it, got answered. And the answer, on the record, was yes. And look at what the judge was actually describing, because the phrase unlawful information gathering can sound bloodless until you unpack it. In that world, it means intercepting voicemail messages. It means hiring private investigators to obtain private records by deception, a practice known in the trade as blagging. It means treating a person's medical details, their travel, their private calls, as stock to be gathered and printed. The judge found this was not a stray incident. He used the word extensive. He placed it across a run of years. This was, in his finding, a method, not an accident. There is one more detail in that judgment worth holding on to, because it puts a face on the finding. The court did not only name the company, it reached the editor's chair. Fancourt said the man editing the Mirror at the relevant time very likely knew of at least one instance of unlawful activity. Now, that man has always strenuously denied any knowledge of phone hacking, and it is only fair to say so plainly. But the judge's written words are the judge's written words, and they are on the public record, and they do not read like the vindication the tabloids promised their readers for years. Now, let's bring in the second case, because it did not end the way the first one did. In January of 2025, Harry's case against News Group newspapers, the publisher of The Sun, was due to go to trial. It never got there. On the day, they settled. And the settlement is where the paper gets loud. News Group issued what it called a full and unequivocal apology. Read the words they agreed to. They apologised for serious intrusion by The Sun between 1996 and 2011 into his private life. They apologised specifically for unlawful activities carried out by private investigators working for The Sun. And they apologised for phone hacking, surveillance, and the misuse of private information at the News of the World. The reported damages ran into 8 figures. Here is why that matters more than a courtroom loss would have. A judge's finding can be argued about. An apology cannot. This was the publisher, in its own voice, signing its name to the words unlawful activities. Nobody forced a confession out of a judge's mouth. The company wrote it down itself. That is not tabloid speculation. That is a document with a signature on it. And this is the pattern the marketing worked so hard to hide. 2 publishers, 2 different roads. One ends in a judge's finding of extensive unlawful conduct. The other ends in the company apologising, in writing, for unlawful activities. Different endings, same core fact. The man they called bitter was, on the record, describing something real. Let me stop here for one plain sentence, because it is the shareable truth of tonight. They told you he had no evidence, and then 2 of them signed the evidence themselves. If Regina Wood is giving you the full picture that other channels skip, take a second and hit the like button. It genuinely helps us reach the people who still think this was all about a grudge. Now, let's talk about the 3rd case, the one that reached its moment this week. Harry's case against Associated Newspapers, the publisher of the Daily Mail, went through a long trial, roughly 10 weeks of evidence. Earlier this year, he was not alone in it. The claimants beside him read like a strange guest list. Sir Elton John, his husband, David Furnish, the actresses Elizabeth Hurley and Sadie Frost, Doreen Lawrence, the campaigner, a former Member of Parliament, Simon Hughes. They accused the publisher of unlawful information gathering, of tapping phones, of obtaining private information through deception. And this week, Mr. Justice Nicklin handed down his judgment. The ruling emailed out while Harry was back in Britain. Now I am going to be careful here, and I want you to notice me being careful, because it is the whole point of this channel. I am not going to tell you tonight who won that 3rd case, as if the final word is already settled and understood. A judgment that long deserves to be read properly before anyone declares a result. What I can tell you is what sits around it, on the record, and that is enough, because Associated Newspapers did not do what Newsgroup did. They did not apologise. They fought. They denied every allegation. They called the claims, in their own word, preposterous. They said the articles were based on lawful sources, on friends and aides and publicists who talked to reporters. So hold the 2 postures side by side. One publisher apologised in writing for unlawful activities. Another stood up and called the same category of claim preposterous. They cannot both be describing the same world, and the court record, case by case, is slowly deciding which posture the evidence supports. Here is the part the coverage skipped, and it is the part I keep coming back to. Every one of these cases is about the same thing Harry says took his mother, not the specific crash, the machine, the hunt, the idea that a person's private life is raw material to be gathered, lawfully or not, and sold. He has said, more than once, that this is why he will not simply take a cheque and go quiet the way others did. And the record gives that claim a spine. He turned down the easy road in the Mirror case and made them face a judgment. He forced Newsgroup to the courthouse steps before they apologised. By every available signal, this is a man using the one tool the boy behind the coffin never had. A document, a finding, a signature. The paper does not forget. Let's widen the frame, because this is bigger than one prince. What observers keep noting is that these cases did something the tabloids spent decades avoiding. They put the methods of a whole industry in front of a judge. The phone hacking scandal of the 2010s produced inquiries and payouts, but a lot of it was settled quietly, in the dark, with confidentiality attached. What Harry did differently was refuse the dark. He wanted the finding in public. He wanted the apology in public. And whatever you think of the man, the public record is now heavier because of it. There are words on the judiciary's website and words in a settlement statement that would not exist if he had taken the quiet money. Think about the long shadow behind all of this. More than a decade ago, there was a public inquiry into the practices of the press, held after the hacking scandal first broke, and it heard months of evidence about exactly these methods. It named the problem. It recommended reform. And then, in large part, the moment passed. The promised second stage never really happened, and the industry moved on. The methods were investigated, argued about, and then quietly filed away. What these court cases did was drag one strand of that unfinished business back into the daylight, and this time attach a judge's signature and a company's own apology to it. That is why this is not just celebrity litigation. It is the part of the story that was supposed to be closed, reopened, on the record. Royal correspondents covering these cases have made the same point in different ways, that this was never only about damages, that for Harry, the paper itself, the written finding, was the prize. And you can see why, if you go back to that 12-year-old and the white card. You cannot get a judgment about 1997, but you can get one about the methods, and he did. And notice what it has cost him, because that is part of the reading too. The same years he spent in these courtrooms are the years the reconciliation with his family frayed, the years the door in Britain grew harder to open, the years he became, to much of the public, the man who sues. By every available signal, he knew that trade and made it anyway. A man protecting a brand does not pick the fight that isolates him most. A man trying to prove one thing about his mother's world might. That is not proof of his motive, but it is a reading the record makes available, and I think it is the honest one. Now, the honest counterpoint, because we always give it its due. The strongest argument on the other side goes like this. Winning some claims is not the same as proving everything he has ever said. In the Mirror case, he lost more sample articles than he won. Associated Newspapers has denied everything and is entitled to the presumption that its denial stands unless and until a court says otherwise. And a settlement, the argument runs, is a business decision, not a confession. Companies settle to avoid cost and risk, even when they believe they would win. That reading has real merit, and I will not wave it away. Settlements are often about money, not guilt. A partial win is a partial win, but here is where it does not fully hold. News Group did not just pay, it apologised in writing, and it used the words unlawful activities. A company protecting itself from cost does not need to sign a sentence like that. It could have paid and stayed silent. The words were a choice, and a chosen apology on the record is a different animal from a quiet check. So let's come back to where we started. That judgment is still sitting on the judiciary's website tonight. Anyone can open it and read a judge finding extensive unlawful conduct. That apology is still on the record, in the publisher's own voice, admitting unlawful activities. And this week, a third judge added another document to the pile. In a case the same publisher fought to the end by calling it all preposterous. For years the story was that Harry made it up. The paper tells a different story. The paper does not forget. Here is the one earned sentence I will leave you with. They spent 20 years writing about him, and in the end, the words that matter most are the ones they had to sign themselves. So let me ask you something, because you lived this in real time. You remember these papers at their peak. You remember the front pages, the headlines about Diana, the headlines about her sons. Knowing now what two of these publishers have put in writing, do you read those old front pages any differently tonight than you did then? Tell me in the comments. I read them, and on this story especially, your memory is part of the record. Subscribe to Regina Wood. And if this walked you through the documents in a way the headlines never did, give it a like so it reaches one more person who still believes he made it all up.